Well, I am Lisa Rodriguez. I'm a Deputy District Attorney in San Diego County. I've been a prosecutor for 11 years, and I'm what we call a dispo deputy, which means I negotiate about 50% of the felonies that come through downtown and come to some kind of settlement with the defense attorney and the judge. In fact, I send you a lot of people. And when I was first called upon to do this program, I was like, this is not what I do. I send people to prison. I am not a social worker. I'm not interested in what happens after somebody gets to prison. That's somebody else's job. They go, they come back, we send them again. You know, they're like Doritos. They keep coming back, we'll make more. So I didn't think so much of this program at first, but I gotta tell you, I have become a believer. I've been working on this for about 1.5 years, and it has really been a privilege. And I like to think I'm pretty privileged to work for Bonnie DeMonis, our district attorney, because you don't hear about DAs that often that are forward enough thinking to be worried about the community on the back end, that are thinking about how can I not only protect the community from criminals after the crime has happened, but how can I prevent it? And that's exactly what this program is designed to do. It's to prevent future crime. It's to stop the process, to keep the recidivism from happening. So it's been a really exciting process, and I want to tell you about the first guy we had. Did the change of plea. The defendant agreed to a stipulated prison sentence, which is all that we're getting here. It's people who are going to go to prison anyway. So he agreed to a stipulated prison sentence, and when he took his change of plea, he was bent over. He'd been to prison many times before. I think he had at least 4 prison priors. He was kind of grunting his answers, mumbling, wasn't looking at the judge, just looked beaten down, the way a lot of our defendants do when they're in custody. So 30 days pass, he comes back for sentencing, and I came to the sentencing. And it was really something special to see this guy now. He's standing up straight, he's answering the judges, he's interacting with the judge. And the biggest difference was that after having been through the 30 days between the time of the plea and the time of the sentencing, he had something that defendants don't usually have, and that's hope. It was a huge thing to him to have people interested in him, checking his teeth, checking his mental health status, giving him testing, talking to him, helping him create a plan for his future. That made all the difference, and that's what this program is about. We're giving people hope. We're giving them a chance to do prison in a better way and to succeed when they get out. And I've talked to defense attorneys about it, and they have said the same thing. They can see the difference in their clients between the time of the plea bargain and the time of the sentencing, because suddenly somebody is interested in them. It's not just biding your time. The government is interested in where they're going and what they're going to be doing. And that is a huge change in our system and in my culture at the DA's office, learning how to appreciate that. So, and I'll tell you one other funny thing that every defense attorney has told me, the defendants are thrilled that they're getting dental assessments. That is so huge that somebody's looking at their teeth and concerned about whether their teeth are in good shape. So it's a really amazing program. We're excited to be bringing it. So I'm going to tell you a little bit about how the courtroom procedures go, because you guys are used to getting the people, but you probably don't have a lot of information on how you get the defendants here. So it starts off with the DA reviewing a case, not just for eligibility for SB 618, but for whether or not we're going to charge somebody. If we get a case from the police, we decide whether or not to issue it misdemeanor or felony. I only deal with felonies. SB 618, as you would know, is only for felonies as well. So a case gets issued, the defendant is arraigned, and at a felony arraignment, a defendant is always going to enter a plea of not guilty, always, because the defense attorney does not have any discovery or any information other than what the charges are. So it'd be malpractice not to enter a not guilty plea. So they enter not guilty pleas, and it gets set for what we call a readiness conference and a preliminary examination. The readiness conference is when the defense attorney and the DA and the judge sit down and talk about the case. Now, before that readiness conference, I get a case file. I get the file, I get the police reports, I get the defendant's prior criminal history, I know if they've been to prison, I know how much time they've done in prison, I know what programs they're eligible. If they're Prop 36 or PC 1000 eligible, those would be drug treatments on a local level. If there's somebody who we should be offering a probation, another stint of probation, or if it's a prison case. So I review the case and I make an offer, what I think the appropriate sentence should be. And then after I review the case, I look to see if it falls within the eligibility criteria that Chuck just told you about. Is it going to be less than 3 years of time to serve in prison? Is it going to be, is this a nonviolent felony? Is it somebody that is definitely a prison candidate? Do they have felony holds? Do they have an INS hold? Is there any reason that they aren't eligible for SB 618? If I'm offering prison and I find that they do meet the criteria, I make myself a little note, SB 618 eligible. Then we go to the readiness conference, and that's where I sit down and talk to the defense attorney and the judge. I make my offer, and I don't even talk about SB 618 at that time, because we're not making SB 618 part of the negotiation process. This is just going to be for people who are already going to prison. So if I make a prison offer, the defense attorney will discuss it with the defendant. The defendant has two options, guilty or not guilty, and they go to preliminary examination. And a prelim is just where the DA has to put on enough evidence to prove that a crime was probably committed and this person probably committed that crime. But if they decide to plead guilty, then they're going to enter into a plea bargain, and they will do what we call our change of plea form, and they indicate on there what our agreement is. And if it's a stipulated prison sentence, they've signed off, then I tell the defense attorney, your client is eligible for SB 618. Then they can go back and talk to their clients about doing the SB 618 program. Like I said, a better way of doing the prison sentence that they were already going to do. Now, we've been very lucky because the defense bar has been very involved in this. They're very interested in it. And we've asked them, when you go and talk to your clients, you need to help us with the screening. Because I can screen for a lot of things. Like I said, I can screen for the eligibility, for the time constraints, I can screen for holds, I can screen for whether they've got prior violent offenses, if this is a violent offense, all those things I can check. But there's things that only the defendant knows and only you guys, the Department of Correction, knows. And that's the stuff like the security housing, protective housing, the prison gang affiliation. If somebody's been assigned to a level 4, you guys know the defendants are very savvy as to what their classification levels are, where they've been in the past. For the men, if they have HIV because they can't be housed at Donovan. So I'm asking the defense attorneys, hey, talk to your clients about this. You don't have to tell us why they won't fit in, why they're not eligible, but they just need to know that if we don't tell us up front, they're going to be screened out eventually. So check with them, let them know, hey, have you been in protective housing? Have you been in a prison gang? Not have you been in a gang outside, because we're taking gang members outside if it's not a violent offense, but have you been in a prison gang? Are you HIV positive? All those things that can help us screen so that they don't get here after we spent all this money on them and they actually are going to get kicked out anyway. And we've also included special needs, and those are things where they're not going to be able to be housed here, that they, like Chuck was talking about, a triple CMS, somebody that is so far removed from the system won't be able to benefit from the program anyway. So if they meet all our criteria, and the defense attorney agrees, and the defendant wants to do it, then they're going to sign this letter of intent. And again, I have to give kudos now to the Superior Court in San Diego, because they have been incredibly helpful with this process. They don't like to have more forms, and unfortunately this program creates more forms. Their first form is a letter of intent, and that's something that we worked on together as a group, and then I took it to the court, and they actually made it a court document, which to have them add another court document to the portfolio is a big deal. And this letter of intent tells the defendant everything that they need to know about the program, all the benefits from it, as well as all the requirements. And it lets them know up front, you're going to be screened. It doesn't say you're going to participate. It says, I, the defendant, would like to be screened for eligibility to participate in the SB 618 program. So they sign that letter of intent. The defense attorney signs that letter of intent. It gets attached to the plea form. And then we have our waivers, more documents. Court loves this. One waiver is for the defendant to agree that all of the people in the multidisciplinary task force probation, sheriffs, the assessors, they can all talk amongst themselves and look at all the assessments to help them develop a life plan. And it just gives them permission to do that. Starting July 1st, we're going to have yet another waiver, which is regarding the SAND Act that Vaughn talked to you about. They're doing these control groups. They're going to be analyzing all the data. So this says that the defendant understands that he's going to be part of a study. So they have to sign those waivers. The court takes the change of plea. They note on the record that the defendant would like to participate. The court clerks, also very helpful. They are actually documenting on the minute order that the defendant wants to participate, wants to be in this program, so sheriff knows where to house them. And then it's set for a probation hearing and sentencing in 20 court days, or about 4 weeks. During that time, oh, and one other thing, after we get the agreement, I enter it into the computer, and it sends out an email automatically to everybody, CDCR, probation, sheriff's department. I think one email goes to parole as well. So everybody knows we've got a new candidate, somebody new in the system, somebody that is going to need to be assessed. It's like a little trigger. So we have all these triggers built into the system so we know where to house people and to get them going on their assessments. During those next 20 days, as Lupe mentioned, probation, the Sheriff's Department, and CDCR are going through all these assessments, these things that are so life-changing to the defendant. Mental assessments, dental, the testings, reviewing the classification, developing that MDT. And then they finally do the probation report, which indicates in the report for the judge to know this person has been found eligible to participate. We go back to the sentencing. And at the sentencing hearing, before the judge sentences the defendant, he signs a contract. Last document. This is a 3-page document that lists everything that is going to be expected of the defendant. And at the multidisciplinary task force, they've gone through that with the defendant. So he's aware of all the things that are being expected and that he still wants to participate. He knows that his life is going to be run by the prison case manager, by the case manager in the community, and that he has to agree to participate. So they're willing, they're knowledgeable, they're educated, they understand what they're undertaking in order to make their lives better. The judge will then sentence the defendant to prison, and they will indicate that they're going to participate in SB 618, and they will attach that contract to the prison pack. So you guys get notification. And one more time, an email comes out, and it lets everybody know that somebody has signed on and they're ready to go. And the court clerks, again, being so helpful, are now indicating on the abstract of judgment that these guys are SB 618 participants. That's helping to ensure they're going to get transported to the correct prison as quickly as possible. And that email is generated. And that is our court process. After that, our candidates are off to RJD or CIW. And so far, I think we have 56 candidates now. 5 have been assessed out. But the program is getting rolling, and we're actually going to have our first people coming out of Donovan in November. So we're excited to see how that's going to work out. But this program, one of the best things about this program has been the interaction and the working together. And I wanted to mention, like with parole, something that's changed now is that when somebody gets out on parole, instead of, if they break the law, instead of sending them back to prison for a new term or sending them back on a parole violation, they're going to be talking to my office. I'm going to have direct contact with parole so they can call me and say, hey, can we put this person through Prop 36 to run concurrently with SB 618? Or is there another way of handling this other than prosecuting them and giving them a new term? We are going to be working with these people in order to do everything we can to keep them from going back to prison, because we understand that part of rehabilitation is falling off the wagon and goofing up. So we've developed graduated sanctions, and we've developed a process where all the agencies are working together to help these defendants or inmates, parolees, participants. So we're so excited you're going to participate, and thank you very much.